because Brianna don't have control of her money. So you're having to submit invoices to fucking Jordan and Cockeye. God knows if you're getting paid. Brianna and I also thought appearing remotely would take some of the publicity off this case. The irony in that is not lost on me. The party in this who has done nothing but live stream and televise all of it, right? And I'm not saying that both of them they both have a social media presence. But there is one party who has went overboard with the live streaming and the televising and publicizing this separation of, or this custody situation, right? That is clear to everyone. So the party who is now saying in court, well, we requested this with his attorney because we thought it would downplay the publicity, so we wanted to do remote. We would like to appear remotely. No, what it is that Brianna is fucking lazy and doesn't want to have to get up out of her house and go to a court hearing for her child because she does not care about her child, which is why every single time she has court the next day, she's out partying, out getting wasted. People on TTS are telling her, don't you think you should maybe go to sleep instead of, I don't know, getting drunk and doing rails? But no. Here we are. Next part of that I found interesting. And believed John and his attorney would feel the same way and want the same thing, but we were wrong. Actually, that was it. That was my last statement on that. Section 4. Since there was nothing about this in the filings to date that I downloaded and reviewed last week, I asked Judge Nord today why some hearings in this case had been with him instead of in our home court 2C. He explained that 2C was scheduled to be closed today when John's 32725 DVRO was filed, and due to my client's right to a hearing within 21 days of filing, the matter was handled by Judge Nord and 2B. I assume this means 2C was also dark on 11525 when Judge Nord and 2B handled John's 11525 ex parte RFO. I already know what she's doing. Section 5. I advised the court today that we were exercising our statutory continuance of the DVRO, and since the DVRO's outcome is relevant to the move-away analysis, we requested the DVRO and move-away RFO to be heard at the same time. Since the latter is currently calendared in 2C for 5/2/25, we asked for the hearings to be combined and moved to a later date. Judge Nord advised he could not move anything on 2C's calendar, i.e. the 5/2/25 hearing date, but that he could add the DVRO to that same date. He stated I needed to file an ex parte RFO to get the matters on 5/2/25 continued. So that is what this is. I explained to Judge Nord that we needed time to subpoena LAPD for admissible evidence as the DVRO, and he confirmed we would not have enough time to complete the process before 5/2/25. Thus, he advised he would make a note in hello? Where am I at? Complete the process before 5/2/25. Thus, he advised he would make a note in the minute court that the DVRO was being continued to 5/2/25 without prejudice as to additional time they may be needed for subpoena. The 4/21/25 minute order is attached. Minute order? Why am I saying minute? Minute order is attached as Exhibit B. Brianna's supervised visitation. Section 6. As outlined in my 4/18/25 declaration, attached again as Exhibit C, less exhibits, John filed an ex parte RFO on 1/15/25 to modify the 10/31/2024 stip and order, requesting that Brianna exercise all her visitation with W in Texas instead of California. The 10/31/2024 agreement was for all of her visits to occur in the LA area. The 1/15/2025 order, attached as Exhibit D, ordered all of Brianna's visits with W to occur in Los Angeles, Orange, Riverside, and San Diego counties. I just can't. Section 7. On 1/16/2025, John filed an RFO on the court's regular calendar alleging the 11525 order was wrong and needed to be corrected. The hearing on that RFO in 2B occurred on 3/17/2025. My client was self-represented at the time, did not appear, and did not file a responsive declaration. So let me just break this down for some people. What this attorney is claiming, right, is that I don't know what's happening. What just happened? Did somebody? Can we not, mods? Can we just stay in the chat and not message in the thing, please? Sorry, I'm not trying to be rude, but I need to feel like I need to read it and I get distracted. I don't know. One of my moderators just messaged me in the Discord. Let's just back up really quickly. They're claiming that John filed an RFO on the court's regular calendar. Basically, he was appealing or alleging that the 11525 order was wrong. So what they're basically saying is that John went into the court with all his supreme power that he has, with all his legal strength, and I guess strong-armed the courts into changing their mind. That is what they want people to believe. That is one of the most insane things that I have ever heard in my life. Because then, to follow it with, the hearing on that RFO in 2B occurred on 3/17/25. My client was self-represented, a choice at the time, did not appear, another choice, and did not file a responsive declaration. So what that tells me, Brianna, is that none of this fucking mattered to you. Why? Because you had the financial means, you're a grown-ass adult, and you are the mother of that child. I don't know about y'all. Again, I'm not a parent, but I can tell you, my mother and I have one of the most contentious relationships I've ever seen between a child and their parent. But if this was the situation, my mom would move mountains to make sure she was in that fucking courtroom that day. Mountains. You couldn't be bothered to get out of bed. What are we talking about? And you're gonna come in a fucking let me stop, because they're gonna take my live down. You're gonna come in that courtroom in front of all these people and look that judge in the face and have the nerve to say that the reason that we're in this situation is because John threw a fit and said, this isn't right, this isn't how was supposed to be. And the courts were like, oh, we're sorry, John. How can we fix this for you? Sir, would you like a cup of tea and crumpets and your feet massaged? I call dibs on that job. It's just crazy. Like, are you that dense, both of y'all? You went to law school? They issued you a fucking degree? Get out of here, bro. What are you talking about? Like, defense to be, she was self-represented by choice. That was her own choosing for 4.5 months while she sat in LA getting ran through by anyone she possibly can. She could have gotten an attorney. She could have hired anybody. Hell, she could have hired me. No, she couldn't have, because I would have laughed in her face. It's just wild. It's just wild. It is very much in line with what I'm seeing a lot on social media of people are doing and saying, and I am not just going to defend 2K. I've said this before. I think the man has made mistakes. He's a man, one, and he's a human, too. Like, yeah, he probably has messed up. I don't agree with everything that I've ever seen from him, but for the most part, I do. And I fortunately have been able to form a sort of respect with him. And I'm not going to be like everybody else and turn my back on him. I can guarantee you that. Because I think that's what everybody's doing. I mean, that not everybody, but I think that's what a lot of people are doing. Nobody's about to convince me that he's the bad guy in this situation. Not perfect. That's not what I'm saying, but he's certainly not the bad guy. The parent who paid for a plane ticket, got on the flight, was able to get to California on time, showed up to court, but the girl who lives down the street couldn't be bothered to get up, to go to court, to hire an attorney to fight for her child. And there are T pages, I say that very loosely because to me a T page comes with some sort of receipt and fact and proof. There are T pages reporting on this, trying to convince us that Brianna's not all that bad. It's 2K that you have to look out for. Stop requesting me, Umar. Anyway, we're moving on. All right.